Right, what this video is going to look at are juries. Now, we're going to split this up into the explanation of juries, so the AO1, Assessment Objective 1, and then there'll be another video evaluating juries and the use of juries. Okay, first of all, what is a jury? Well, it's a group of 12 randomly selected lay people, and they are chosen from the electoral register, and they decide upon the facts of the case and whether somebody is guilty or not guilty. So they don't look at legal issues, they just have to decide the verdict of the case. So what is their role? Well, first of all, they are used in the Crown Court when the defendant pleads not guilty. Now, this could be pleading not guilty to an indictable offence, such as murder or robbery, or they plead not guilty to a triable either way offence and they have elected trial by jury. So they plead not guilty to theft and choose to go to the Crown Court. So they listen to the facts of the case. The prosecution will speak first of all, and they listen to the evidence in chief, so the prosecution witnesses. They will then listen to the defence, cross-examine those witnesses, and then they will listen to the defence give their witnesses in court, and they will question their witnesses, and then there will be cross-examination of those witnesses. So after that, they listen to the summing up from the prosecution and the defence, and they will listen to the judge sum up the facts of the case. Sometimes the judge will have to direct the jury on legal issues. For example, murder, they have to be sure that the defendant intended serious injury or to kill the victim. After they've listened to all the summing up, they will retire to a private room to consider the verdict. Now, nobody else is allowed in there. It has to just be the 12 of them. They must all reach unanimous decisions. So all 12 must agree guilty or not guilty. Now, after a while, it's very difficult for 12 people to all agree the same thing. After a while, the judge may call them back into court and say, are you going to reach a unanimous decision? The foreperson, somebody who's chosen from those 12, will stand up and say, unlikely. Therefore, the judge is likely to say, well, I will accept a majority decision. So if there are 12 of you, 11 to 1, 10 to 2. If there are 11 jurors for some reason, that could be 10 to 1. And if there are 10 jurors, 9 to 1. They can't discuss the details of the case or how they reach their decision with anyone else, and it's actually a criminal offence to do so. The other thing just to bear in mind is juries are sometimes used in coroner's courts where they decide how somebody dies. Okay, so jury qualifications. This could be a potential other question. So who can be on the jury? Well, first of all, who can be on the jury is set out in the Criminal Justice and Courts Act 2015 and the Juries Act 1974. So a juror must be aged 18 to 75. They must be registered to vote on the electoral register. Another requirement, they must have been a UK resident for 5 years since the age of 13. They cannot have any serious mental health disorders or be disqualified, and we'll come on to that in a second. If you're in the armed forces, then you may be excused. Now, what happens if you've got a hospital appointment or a holiday booked when you're called up for jury service? Well, discretionary excusal. So you've got your A-levels coming up, you're called up for jury service, you could ask to defer. Now, you are allowed to defer once, and you can only defer for up to a year. And you would put the reason down on the jury summons, and the judge would decide whether you are allowed to defer. On that form, you must state when you are able to do it. So if I was called up in June, I would say, please can I be deferred? My students have got their A-levels, but I am available the first 2 weeks of November, for example. So who is disqualified? Who cannot do jury service? Well, if you are in prison, clearly you can't because you are in prison. Also, if you are on bail, you're not allowed to do jury service. Anyone with a serious mental illness. If you are deaf and you have somebody who signs for you, you can't do jury service. That would be a 13th person on the jury. If you have ever had a prison sentence of 5 years or more, you cannot do jury service ever. You are completely disqualified. However, if you've had a prison sentence for under 5 years or you've been given a community sentence, then you can do jury service, but you are actually disqualified for 10 years. So you have to wait until you haven't committed a crime in 10 years in order to be able to do jury service. Now, When you get the jury summons, you are summoned for 2 weeks. That's a normal length of time. Frequently, cases last longer than this. So the computer selects names from the electoral register. You get a letter on your doormat and it's calling you up for jury service. You go to your local Crown Court. There are 2 types of vetting that take place to check you can do jury service. So first of all, police checks, like a DBS check to see if you've got any criminal convictions, and then a wider background check. Political checks are sometimes made in exceptional cases. So you would need the Attorney General's permission, and they would be cases such as national security and terrorism. When you go to court, there are 15 of you in the courtroom and 12 names are pulled out of the hat, and then you are sworn in. You either swear on the Bible or your relevant holy book, or you just take an oath. And often you see on television programs in America, juries are really selected and chosen, and they get rid of jurors here and there. In England and Wales, it doesn't happen quite like that. So there are 3 challenges that can be made to the jury, but they're very, very unusual. They very rarely happen. Okay, so first of all, challenge to the array. This is hardly ever used. It's kind of a historical thing. And this is a challenge to the whole jury on the basis it's been chosen in an unrepresentative way. And if you think about it, how can it be chosen in an unrepresentative way? Because it's done randomly from the electoral register. So I think this stems back to the olden days when it wasn't quite as random. Challenge for cause. Now, this is a challenge made about an individual juror. So there must be a valid reason why the juror shouldn't serve. So it could be that you know somebody in the case. And then the final challenge is the prosecution right to stand by. So only the prosecution can do this. And what would happen is they don't have to give a reason, but generally they do, because the defence need to agree that this person shouldn't be on the jury. So unsuitable jurors could be removed. For example, if it's clear that somebody can't read and write, then it may not be suitable that they sit on a highly complex case with lots of documents. If it's a theft or a fraud case, it's going to be difficult for them to understand things. So the prosecution have this right to stand by. If the defence agree, then that person does not serve on the jury. And also, the judge does have the power to remove a juror. It is unusual to do this, and you can't do it to obtain a diverse jury. So you can't do it to have a balance of men or balance of women or different minority groups. Okay, so tune in for the next video, which is the evaluation of using juries.